possession and had stopped safely. Car number one, car number two stopped safely. Other cars avoided the accident by moving out of the way. The defendant was driving too quickly and too closely to safely stop. The defendant's car hit Mrs. Burrell's car. Mrs. Burrell will be here to tell you. She is a witness, and I will put her on the stand, and she will be able to testify as to what happened in the accident. Despite being hit, Mrs. Burrell was the second car. Despite being hit, she was at a safe distance, and hit hard. She was at a safe distance to avoid hitting the car that was in front of her. She was traveling safely. You will hear from several drivers on the scene. I don't know if the defendant will talk about it. He has no obligation. He was a driver. I will present Ms. Burrell, whose car was hit, Ms. Shaw, whose car was not hit, and Ms. Mayo. You will also hear from the officer. The officer came upon the scene after the accident. He investigated the scene by speaking to all of the drivers and by relying on his training as an investigator of accidents. He is considered someone with special training to investigate accidents. At the end of the trial, I will ask you to find the defendant guilty of A, following too closely, and B, driving too fast for conditions. Thank you for your time.
All right. Mr. Takbiadan, as we've discussed, you may make an opening statement if you wish.
Hello, jury. My name is Volter Manantan Takbianan, and I am defending myself today because of the car accident. Just to tell you formally that I was driving on the road at 55 miles per hour, using my automatic traveling at 55 miles per hour, and I am using a dash cam video that I am far away from the car that I'm following with, that can easily put 6 to 7 cars in front of me. What happened was there's a dash cam on the top of my car, and my eyesight is below, and I couldn't see up ahead. So what happened was there's a car, the red car in front of me that I could not see, that traveling and then suddenly stopped unexpectedly due to a funeral procession that is happening on the other side of the road. And what happened was it stopped, and the car behind her also stopped. But there's a truck behind them that avoided collision. And there's a black car in front of me that I can only see the black car behind me. In front of me. And what happened was I couldn't see far ahead was in front of me, which is the black car. And what happened was he suddenly avoided traffic without turning lights going to the right. And I was worried that there might be a car beside me. And by the time the black car in front of me moved out of the way, I see two stop cars that has no hazard light, and I do not know if they're moving or not. So it takes a fraction of a seconds for me to think whether they are moving or not. And I realized that they are not moving. So I slammed on the brake, and by the time I hit the car behind, and that was caused the accident. What really caused the accident is the red car stopped improperly during the funeral procession, and it was stopped in the middle of the road beyond the yellow line or the shoulder. So what causes the improper stop is, let's see, rear end collision could cause it, obstruction and visibility issues, loss of control, or chain reactions. So what happened was the truck moved out of the way, and then the black car moved out of the way. By the time I see what's going on, the danger in front of me, which was a surprise, it's hidden from me. So that's when I realized I am in trouble. And so I hit the brake and caused the accident. So but that's what happened, and thank you for your time.
Thank you, Mr. Tachyon. Members of the jury, I'll remind you again that what the attorneys say and what the defendant says when he's acting in the role as an attorney are not evidence. The evidence actually hasn't been opened yet. At this time, now that opening statements are concluded, now the evidence is open. And from this point forward, you'll be hearing evidence in this case. Ms. Sexton, the floor is yours to call your first witness.
The state calls Officer Crumpler. Is this on? Oh, yes, it is. Okay, wasn't sure.
And y'all can move that around wherever you'd like.
Officer Crumpler, do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? So
I do.
Can you state and spell your name for the record?
Deputy Joseph Crumpler. Last name is Crumpler.
And sir, how are you currently employed?
I'm currently employed by the Bibb County Sheriff's Office.
And where were you employed at the time of the accident?
I was employed by Spalding County Sheriff's Office.
And can you tell me a little bit about the history of your employment with the Spalding County Sheriff's Office?
So in total, I want to say it's been about 4.5 years in total that I worked for the Sheriff's Office. I worked here for 3.5 years, had a brief hiatus at another department, and then I worked here for approximately 10 months before going full-time at Bibb County.
Okay, and you currently work in Bibb County for what reason, sir?
I live in Bibb County, small commute.
So, can you give me a little bit of your background as far as your training as an officer who investigates traffic accidents?
So the only actual training I have as far as accident investigation is what they teach you in mandate and what I was taught during FTO. There's a, I believe, 16 or 24-hour course in mandate that gives you the basic outlook of how to investigate an accident, what information to collect, and then the FTO process through Spalding County.
And how many accidents, I don't expect an exact number, but ballpark, how many traffic accidents as a officer would you guess you have investigated?
On a normal week, I would say at least between 3 and 5, because GSP works the majority of the accidents in Spalding County. But over my entire career, I'd probably say close to 1,000, if not more.
All right. And because of your experience and because of your training, what do you look for when you come upon an accident scene?
So one of the things we look for is obviously where the vehicles are currently located. Make sure that all the occupants are okay. They don't have to be checked out by medical, EMS. Then you look for the initial point of impact. When two vehicles collide, normally some sort of debris field forms at the point of impact, even if the cars are 20 feet up the road. Because when your taillights and headlights hit, there's going to drop glass. So you try to find the initial point of impact, any secondary or so on points of impact to build the diagram.
Okay, did you investigate an accident on 4/26/25 on Georgia 3?
I did.
And can you tell me, were you on duty that day?
Yes, ma'am.
How did you come upon that accident? Did you receive a phone call? Did you receive a radio call? How is it that you came upon that accident?
I received a radio call.
And when you presented at the scene, were you in uniform with a badge?
I was.
Were you in a marked vehicle?
I was.
Did the accident occur in Spalding County?
Yes, ma'am.
And the investigation occurred in Spalding County?
Yes, ma'am.
Okay. Have you had a chance to review your accident report in preparation for coming here today?
Yes, ma'am.
Did that accident report refresh your memory about an accident which occurred several months ago?
Yes, ma'am.
And Can you tell the jury, to the best of your recollection, in an organized manner, from the time you appeared on the site, can you tell me what your actions were?
So I responded to the scene of the accident, which was on North Expressway, also known as Georgia 3. It was near, I believe it was Minter Road, the dirt road right past the trailer park, north of Birdie Road. In the right-hand lane, or sorry, in the left-hand lane of the northbound side. The third vehicle on the accident report is going to be the vehicle that's not involved. Initially, we believed that her vehicle got clipped by the secondary vehicle. She pulled over to the left-hand shoulder to pay her respects to the passing funeral. The vehicle number 2 pulled safely behind her. Same thing. Came to a stop to pay respect to the passing funeral procession. And then the vehicle 1, which is the defendant's vehicle, failed to come to a complete stop and collided into the rear vehicle number 2, which sent vehicle number 2 around vehicle number 3, coming to a complete stop.
And based on your investigation, did you believe that there were any violations of Georgia law?
Yes, ma'am. So, too fast for conditions. I wrote that citation due to the fact that too fast conditions isn't just about speed. Things that can be considered conditions are the weather, traffic congestion, funeral processions, etc. You have to take in the totality of the circumstances. So I wrote him a citation for that because if he wasn't going too fast, he would have been able to stop. And then I wrote him for following too closely because he made a comment, which may be on body camera, may not be, that he was traveling behind another vehicle. That vehicle got out of the way due to seeing the vehicle stop in front of him. And when the vehicle in front of him moved, he failed to come to a complete stop in time, colliding with the other vehicles.
So you had a discussion with the defendant at the scene.
Correct.
Did you have a discussion with any of the other drivers at the scene?
Yes, ma'am.
And in summary, can you tell me what those particular drivers said?
Vehicle 3 pretty much says she pulled over to the left-hand shoulder due to the funeral procession, and same thing with Vehicle 2.
And vehicle 3, although they were part of vehicle 3 was towards the median, is that correct?
Yes, and so there's the grass median in between them. They pulled over slightly, not into the grass, but pulled over slightly. Same thing with vehicle number 2. And then when the accident happened, vehicle number 2 went around vehicle number 3.
Okay, so at the time of your investigation, did you determine that any other vehicles had violated any Georgia state law?
No, ma'am.
Okay, so the defendant was the only car in that situation that violated Georgia law?
Yes, ma'am.
Okay. Have you had an opportunity to review any video regarding this circumstance?
You showed me a video earlier.
Okay. Do you believe that, Your Honor, the state would like to tender as State's Exhibit 1, the defendant's video?
Okay. Mr. Takbianan, do you have any objection to the state playing
No,
the
Your
video?
Honor. No, Your Honor.
Okay. All right. All right, then, and I'm going to say that States 1 is tendered and admitted without objection. The court will need to get a physical copy of it at some point, just for record purposes, but we can cover that bridge later. All right.
The defendant actually has the video. The defendant actually presented it, so that would probably be the easiest.
That's fine. I think you have it on a thumb drive.
Yes, sir.
Perfect. We'll sort that out at a break. Okay. All right. Let me push this up. You ready, Ms. Sexton?
I am. Let's pray all systems are go from a technological standpoint.
All right. Here we go.
Oh, here we go. Hold
There
on.
we go. Yeah. Oh, I hit the wrong button. That's on me. Ready?
So let me preface this, even though the state is presenting this as evidence, the state had no evidence of the actual accident. This is the defendant's dash cam on his car that he's presenting as evidence.
Is that correct?
Correct. This is going to be his video.
Your Honor, this is in essence, unless the defendant objects, this is in essence the
You pause it. All right, there's about 20 seconds left. Do you wish for it to be played to the end, or is it okay to shut it off here? You have that right to make that decision.
Yes, Your Honor, I have it.
Would you like it played to the end?
Yes.
Okay.
Oh, well, no, not really.
You're
That's
okay
it.
with
Yes, I'm okay
the
with
amount
that.
that was played?
Yes.
Okay,
That's what's
let's
good
just make,
enough.
that was me talking over you. That was my fault. Are you okay with where it was stopped before the jury?
Yes, Your Honor.
All right, good questions, get good answers. Sorry about that. All right, thank you, Ms. Sexton. You may ask your next question.
You did not have the opportunity to see that video prior to today, is that correct?
Correct.
And I just recently showed you that video, is that correct?
Yes, ma'am.
Is that an accurate representation of what your accident investigation revealed?
Yes, ma'am.
Does anything about that video that you have not previously seen, watching that video, does anything about your investigation change?
No, ma'am.
Do you feel differently about what happened?
No, ma'am.
All right. State rest. I mean,
Sorry, all the questions. All right, Mr. Takbianan, you remember me saying at this moment you may ask questions?
Yes, Your Honor.
All right, so you're doing good with the mic. Do you wish to ask this witness any questions?
Sure, I could ask just a few.
Okay.
Mr. Crumpler, did you observe the red car inside of the yellow line when you arrived there?
The driver's side tires were on the opposite side of the yellow line, on the median.
Okay. Do you think that is to stop at the inside of the traffic line? Do you think that is unsafe in your thinking, in your judgment?
Depends on the situation.
Okay. And you said that you have measured the skid mark of 109 foot when I hit the brake. Is that correct?
I'd have to look at the paperwork, but if you have the report, I'm assuming that's what I put.
Okay, no further question.
Redirect.
redirect. Officer Crumpler, the video that we just saw, am I correct that not only did vehicle one, I don't know what the number is. We're going to call it the first vehicle, the red vehicle that stopped for the funeral procession. They stopped safely, is that correct?
Correct.
Vehicle, the second, the white car, Miss Burrell's car, she stopped safely, is that correct?
Correct.
In addition to that, there were multiple vehicles that moved out of the way, is that correct?
Correct.
One of the vehicles that moved out of the way was, I'm going to call it a black car. Do you remember seeing that in the video?
Yes, ma'am.
Do you remember seeing the black car's brake lights go on substantially before the accident?
I wasn't paying attention, to be honest with you.
Okay. And there was also a truck that moved out of the way.
Correct. In front of the black car.
Okay, so we have the red vehicle, which safely stopped. We have the white vehicle, which safely stopped. We have a black vehicle, which safely went around the situation, and we have a truck that went around the situation. Is that correct?
Correct.
And all of those vehicles were closest or closer to the red vehicle that stopped than the defendant's vehicle. Is that correct?
Correct.
As a matter of fact, the white vehicle was so far behind the red vehicle that when it got hit, not only when she was struck, she avoided hitting the vehicle in front of her because she was at such a safe distance behind the vehicle. Is that correct?
Correct. Initially, I thought the two collided, like clipped a mirror or something, but I believe you said they had no damage. after the fact.
So the second car, which was totally and completely stationary and safely stopped, when it was hit at high impact, it actually had enough distance to go around the red vehicle
Correct.
without striking the red vehicle. Thank you, Your Honor. Thank you, sir.
Mr. Beyond, you may recross, if you will. You may ask a few more questions if you would like.
Yes, Your Honor, I would like to recross. You saw the video evidence and you see the red car and the car behind it is unsafely stopped in the middle of the road, still inside the traffic. As I said before, when you are stopping for an emergency or even paying respect on a funeral procession, on the other side of the road, you're not obligated to stop. But since they stop in an unsafe manner that it potentially cause prone to accident, as I said before, an improper stop at traffic lane could result in rear-end collisions, obstructions of visibility issues, and loss of control or chain reactions. So that's exactly what happened when somebody stopped improperly in the middle of the traffic. As you can see, I was so far behind that.
Okay, hold on. So again,
Sir.
you've put a lot on the table, but this is a chance to ask this witness
Yes, sir.
questions.
Okay.
So break it down, chunk it down into smaller bite-sized pieces and ask questions, not make
Yes, sir.
statements.
Okay. So as you can see, officer, I was far behind, and you can see the speed that I was traveling. I'm not going too fast, nor I was following too closely. That's all, Your Honor.
All right, you can answer that as best you can. Okay. All right. Do you wish to ask any more questions of this witness?
No, Your Honor. That's it.
All right, thank you, Mr. Takmian. All right, you may return to your seat.
Your Honor,
Yes.
the state would like to request that the officer be allowed to leave. He has a medical appointment unless
Okay.
Your Honor
Do you,
objects.
do you have any objection to this witness being released?
No, Your Honor. No
All right.
objection.
Then you are free to stay or go as you please.
Appreciate it, Judge.
All right. Does anyone need a quick break before we jump into the next witness, or are y'all good to keep going? All right, y'all are all nodding, say keep going. So I got a couple thumbs up and a couple nods, so you may call your next witness.
The state calls Ms. Burrell.
Yeah, Margaret's got it.
Oh,
David got it.
give us a second.
You can come on up, man. You may put your purse wherever you wish, and Miss Sexton is going to swear you in.
Ms. Burrell, do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? Yes, ma'am. Thank you.
All right, you may be seated.
Thank you. Can you please state your name and spell your name for the record?
Sheila Burrell, Shelia Burrell.
And Ms. Burrell, you were driving the white vehicle that sustained property damage at the time of the accident, is that correct?
That's correct.
Okay. Do you recognize the person who is driving the vehicle that struck the back of your vehicle in the courtroom today?
I didn't until I saw it. They said he was representing himself, so I guess that was him.
Okay. And you had an opportunity to view that video,
Yes,
and
ma'am.
you hadn't previously seen it. I just showed it to you a little while ago, correct?
That's correct. That's correct.
And you hadn't had an opportunity to talk to any of the other witnesses or anything, ask them any questions? You
No,
just
ma'am.
watched it so we could refresh your memory, is that correct?
That's correct.
Okay. Can you tell me, in your own words, what happened on April 26, 2025 in Spalding County?
I was going north on 1941, and
Where were you going, ma'am?
I was going to my mother's house, which is on School Road, which is like, I don't know, half a mile from where I got hit. But it's going north on 1941, and on 1941, there's a big grass area, dip, and everything on the other side. And all of a sudden, I saw this girl stopped for no reason. I didn't know what the reason was. I mean, she just stopped, so I had to slam on my brakes to keep from hitting her. And then I got hit from behind.
But you safely stopped, is that correct?
Yes, ma'am.
And not only that, but after you were struck
Yes,
from behind
yes,
at a high rate of speed,
yes.
you were far enough away from the red car in front of you that you actually wound up going around it and not hitting her, is that correct?
That's correct. That's correct.
And whose car was it that you were driving now?
My mother's.
Okay, and did it sustain property damage?
Yes,
And did it need to be repaired?
yes,
And did it need to be in the shop for a period of time?
yes. Yeah. So probably about 3 weeks.
3 weeks?
Yeah.
Okay, I believe that's all I have.
All right.
Uh,
Mr. Tachbian, you may ask this witness questions. I'll just tell both of you, just make certain to take a deep breath and let him finish, and then take a deep breath and let her finish. And that way we'll get a good record and everybody can hear everything.
Yes, Your Honor.
All right, you're good to go. You may ask your first question.
Yes. When you were following a car in front of you, did it stop safely on the shoulder or not?
No, she was not on the shoulder.
So you said you slammed on the brake and thankfully you avoided the collision.
Yes. I
No further-
stopped before hitting her. Yes, that's
Yes.
correct.
Okay. No further question, Your Honor.
All right, redirect.
So would you be surprised if the officer said, or if the video said that part of her car was to the left of the shoulder and that indeed that was part of the reason that you were able to go around her when you were hit? 'Cause
I don't know, that was April and it happened so fast. Maybe she was some on the grass, but she couldn't have been very far on the grass.
okay. That's all, Your Honor.
All right, any recross?
Yes, Your Honor. The fact that I hit her from behind and she stopped is after the fact that she already stopped. When I hit her, she.
Hold on, you're doing a statement. That's okay. It's all right. So you're doing a statement again.
Sorry.
It's all right. You just need to ask a question of this witness.
Sorry. Okay.
It's
It's
okay.
my first time. Sorry.
This is my job. This is my job. I love my job. Just
Yes.
ask questions.
Yes. When I hit you from behind, you already at the rest stop, right?
I had
Before.
already stopped. Yes.
And when I struck you from behind you, the momentum carried you forward that you avoided the other car from hitting by going around it. Is that correct?
Yes, I think.
No further question, Your Honor.
All right. Any objection to her being released?
None, Your Honor.
Okay. May she be released? Any concerns with her being released?
No, Your Honor.
All right. You are released from your subpoena. You may stay or go as you please.
Oh, I'm leaving.
Thank you.
Thank you. I gotta go to work.
All right. Then you can come across the courtroom this way if you want to go out that way, if you wish. All right. You may call your next witness.
Your Honor, the state calls Caroline Shaw.
All right. Miss Margaret Scouter. Miss Sexton is going to swear you in.
So if you'll raise your right hand. Do you swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
All right. Can you just speak into the mic a little louder?
Yes, ma'am.
Can you state your full name and spell your name for the record, please?
Caroline Shaw, Karoline Shaw.
Okay. And Were you involved in an accident on 4/26/25?
Yes, ma'am.
Okay. Can you talk to me a little bit about what happened that day?
I was on my way to eat for my brother's birthday party with my son, and we were headed north, I believe, if I remember correctly. And I seen a funeral coming towards us. So me just growing up, as I've learned, pay your respects and get over. So I got over, and then all I know is there's a car being hit.
Okay. On that particular day, was your vehicle damaged or involved in an accident?
No, ma'am.
And how is it that your vehicle was not involved in the accident? Can you describe that to me?
I guess she was far behind to go around me.
Okay. And who else was in your vehicle on that day?
It was my 4-year-old and my his dad.
Okay. And how did you know that there was a funeral procession?
I had already seen the funeral hearse and all the headlights, the hazards.
All right. After the accident, did you speak with anyone?
No, ma'am. Only the police officer.
Only the police officer?
Yes, ma'am.
Is there a reason that you didn't talk with anyone after the accident?
I have bad anxiety, so it just gets the best of me.
So the person that you spoke with was the officer, but no one else?
Yes, ma'am.
All right. And to confirm, your vehicle was not injured, your vehicle was not property?
No,
There
ma'am.
was no property damage?
No, ma'am.
And did you pull over, not into the median, because the median is a swale and it goes down, is that correct?
Yes, ma'am.
So if you were to pull too far over, you would be dipping in, it would not be safe?
Yes, ma'am. And my son is on the driver's side, and I didn't want to put him in the ditch.
All right, so you didn't go into the ditch, but did you go into the grass?
Yes, ma'am.
All right. And about how long would you say that funeral procession was? I mean, was it long enough for you to notice that there was a funeral procession?
Yes, ma'am. There's a good amount of cars. There was even cop cars.
Okay, and did the cop cars have their lights on?
Yes, ma'am.
All right. Did you see the defendant hit the vehicle?
No, ma'am.
Did you?
I just seen him coming up from behind us.
Okay, can you describe that and how you would have seen that?
So after I made a stop, I just looked in the rear view just to look, and I seen a black truck go around, and then I seen him come up and hit us. It hit the white car behind me.
Okay, and the white car did not hit you?
No, ma'am.
And how did the white car avoid hitting you?
She went around me.
Okay. And when you looked in your rearview mirror, was that white car directly behind you, or was it some distance behind you?
She was kind of staggered in from a distance.
All right. Did you? Okay, thank you. I don't have no further questions from the state.
All right, so sit tight just for a second. Mr. Takbian, would you like to ask this witness any questions?
No, Your Honor.
All right, then that means your testimony is completed, ma'am. You are free to stay or go as you please. Thank you.
Thank you.
All right. Call your next witness.
The state will call Yolanda Mayo.
Okay.
Ms. Mayo, do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
I do.
And can you state and spell your full name for the record?
Yolanda Mayo.
And you could sit down.
That's okay. That's okay.
First name is Yolanda. Last name is Mayo, Mayo.
Okay. And your vehicle was not hit, is that correct?
That's correct.
your vehicle did not hit anybody, is that correct?
That's correct.
Okay. We have discussed that the red vehicle, Miss Burrell, oh my goodness. Give me 1 second. Ms. Shaw's vehicle, the red vehicle, was pulled over slightly to the side, not in a median that goes down, but to the left side, partially in the grass. We've discussed that that vehicle was stopped. We've also discussed that there was a white vehicle behind that vehicle, which was stopped. And we know that the defendant's vehicle hit the white vehicle. Does that sound like the video that you witnessed?
Yes, ma'am.
Okay. Because you are none of those vehicles, with the court's permission, the video is very short. I'm going to re-show the video, and I would like for you to describe to the jury who you are in the video. Is that okay?
Yes, ma'am.
Your Honor. Hold on, Your Honor, I'm having a minute. Sorry, Your Honor, I'm having a minute.
Just let me know when you're ready for me to push it up the screen, that's all.
Okay, thank you. Your Honor, can I ask for assistance for a second?
Sure.
My apologies to the jury.
Ready?
Again, accept my apologies.
You ready for me to push it up the screen?
Hold on 1 second. Let me
Sure.
just make sure I got it right. Yes, Your Honor.
All right,
Hold
here we
on.
go.
Let me back up. Hold on.
Okay, it's on the screen.
Okay.
Let me pull my little piece off of the screen there. Give me just 1 second.
Sure.
No, it's not. There we go. Okay.
So, Ms. Mayo, one of the reasons that I'm re-showing this video is because we know there's a black car that moved out of the way, and we know there's a truck that moved out of the way, but we're trying to figure out exactly who you are, okay?
Yes, ma'am.
Okay. So we're watching this black car here, and you're going to be able to see brake lights right there and moving away.
Is that your van, ma'am? Is that? Okay. You pulled over
Yes, ma'am. Still working.
and
Hold on. Just exit, if you'll just pause it. I'm a little worried that the jury won't get your questions over the music from the
Okay.
video. So
Thank
if
you.
you'll just pause it when you're gonna ask questions, and that way we can all get it, and Lisa
Sure.
won't kill me.
So because I might have not been heard over the music, you're the van that pulled over to the right.
Correct.
Okay. Can you, and you pulled over to the right after many, many, many cars had already passed that accident scene, is that correct?
Correct, because I was in the same lane as the accident.
You were in
So
the
I was
same,
stuck in traffic trying to get over.
right, so you were
Sorry.
in the same lane as the accident
Yes, ma'am.
and you avoided the accident.
Yes, ma'am.
And so did all of the other cars that we see traveling in this video that are also going to the right and going around, is that correct?
Yes, ma'am.
Okay, so did you have an opportunity to talk to anybody at the accident scene?
I was just on my way to work immediately. I just stopped to check on everyone, make sure everyone was safe and not hurt.
So for lack of a better word, you were just stopping, even though you weren't involved in the accident and you didn't cause the accident didn't cause any damage to your car, you were just stopping to make sure that everybody was okay.
Correct.
But you would be able to talk to us about what was going on with the traffic that day.
Correct.
Okay, can you tell me a little bit about that?
I was traveling 1941 northbound. I was actually headed to work. I work over in McDonough. And everyone was traveling along fine. And then all of a sudden, the traffic in that lane I saw cars just swerving over to the right. And then I saw brake lights and I swerved. I got over as soon as I could safely without causing an accident myself. And then I moved over to the right-hand side of the road and then got out and checked on everyone and that was in the vehicle.
So I didn't count how many cars were able to avoid the accident who were not driving too fast for conditions and were not speeding and were not following too closely. But we do know that many cars avoided this accident. Is that correct? Okay. And after you asked everybody if they were okay, did you have any other discussions with them about how the accident occurred?
No, ma'am.
Okay. Thank you for your help here today. I have no further questions, Your Honor.
All right. Mr. Takvianan, would you like to ask this witness any questions?
Sure, Your Honor. When you're driving down that road that day, is the condition normal to you? Seems normal to you, like traffic conditions are normal, correct?
For that road, yes.
And you testified that all of the sudden there is something going on ahead of you that could cause potential danger. Is that correct? No further question, Your Honor.
All right. Any redirect?
No, Your Honor, I'm fine. Thank you.
Then, ma'am, that concludes your testimony. You may stay or go as you please. So if you want to go, you're welcome to go. If you want to sit out in the gallery, you're welcome to sit out in the gallery. Whatever you'd like to do is your choice.
Thank you, sir.
Thank you. All right. Members of the jury, this is a good time for a quick break. So here's what we're going to do. You all are going to step back into the jury room there. In just a second, I will tell you, don't talk about the case. Do not do any homework. You're to get your information about this case from two sources only: the witnesses who testify from this seat and the exhibits that are placed into the record, the law that I give you, and nowhere else. As soon as all of you have had a chance to step into the restroom, stretch your legs, grab a cup of coffee or whatever you'd like, knock and let us know that you're ready to come back out, and that'll be our signal to continue. All right? Thank you very much. If you all step back into the jury room. Mr. Takmianin, I need to have a very formal conversation with you. And this is my job to do this at this moment, which is to make certain you hear me say, you have no obligation to testify. Do you understand that you don't have to say anything?
Yes, Your Honor.
All right. Do you understand that if you choose not to say anything, I will tell the jury that they are not allowed to hold that against you? Do you understand that?
Yes, Your Honor.
But if you choose to testify, I will have you come up here and I'll put you up here in the witness seat. I will place you under oath in front of the jury again. And then I'll let you testify. And then Ms. Sexton will ask you questions. And as long as they're allowed and appropriate, you will have to answer those questions. Do you understand that?
Yes, Your Honor.
Do you have any questions for me about anything about choosing to testify or not testify as we go forward?
As you said, I could remain silent even if I was asked a question.
Yes,
Or I
your
may answer.
questions for the witnesses, you have not waived that right. But if you choose, because what's about to happen is when the jury comes back out, Ms. Sexton has just indicated that she's going to rest, which means I'm going to look at you and I'm going to say, in front of the jury, you have no obligation to testify, but if you want to testify, this is your opportunity to do so. And then I'm going to say, do you want to testify or do you want to remain silent?
I'll probably remain silent.
Okay,
Be safe for me.
that's fine, because that'll tell me then if that's the case. So take another moment and think about it, because I'd like you to move that from a probably to a definitely, because that'll let me know what to do next.
Okay.
And that's okay. So take just a minute and think about that. If it's definitely, that's fine. But if so, we're going to move quickly into closing arguments. And do you know if you're going to want to go first or last or both?
I'm just gonna do last.
Okay.
I'm trying to move this along.
That's fine. So what that means to you is that these things will happen very quickly. And I haven't finished my jury charges yet, so y'all are getting ahead of me. Good job. So when the jury comes back out, Ms. Sexton will stand up and says she rests. Is that correct?
Yes, Your Honor.
I will then turn to you and I will say, for the jury's ears, I will say, you are under no obligation to testify. But if you wish to testify or offer evidence, this is your chance. Do you wish to testify or do you wish to remain silent? And you will say,
I wish to remain silent.
that's perfectly fine. Just making certain we've covered that. At that point, I will turn back to the jury and I will say, members of the jury, the defendant has elected not to testify. You will not hold that against him. And I will charge you with that in my final charges. At that point, we'll go into closing arguments.
Yes, Your Honor.
And they've elected to go second, which means you'll go first, and that'll be your chance to sum up what you think is the most effective information from the trial for your benefit, for them to find you not guilty. And then
Yes,
Ms.
Your
Sexton will sum up the opposite of that, and then the jury will have it, because as you all have already signed and approved, I have the verdict form right here with the attached amended accusation. I just need to go finish the jury charges real quick, which I'm almost done with. So,
Okay.
all right. If you will tell the jury that I'm just doing a little bit more housekeeping, but that this is very effective and we're perfectly on time. I just need a few minutes. All right, we're gonna go in recess while I type up the last of the jury charges and print them for you. All right, everybody, let's come back to order. All right, so y'all did get a little ahead of me, so I did finish up the jury charges. There are very likely some grammatical errors. If you find them, tell me. I will not reprint them, but I will scratch out, and correct. And again, the way I normally do this is I'll read my jury charges to line 295 on page 17. And then I'll stop, then y'all do your closing, and then I'll do my last little bit there. And it says, end of pre-closing argument instructions. Except that I misspelled instructions because I just typed it and I typed it fast. So it is what it is. All right, Ms. Sexton, anything else?
No.
All right, I've written an I on there for instructions. Okay, Mr. Takbian, do you understand what what this is? The charge to the jury is the law that they're responsible for following in making their decision in this case.
Yes, Your Honor.
Okay, so you're welcome to point that out. I've also asked Ms. Margaret to make copies of the verdict form. You each have your own copy. I have the original. You may do with it as you see fit or nothing at all. I just want to make certain that as you all got into your closing, you each had a copy of my instructions and a copy of the verdict form. When the jury goes out to deliberate, the only exhibit is the video, but of course that's not going to go out with them. So if they want to watch it again, they can ask and we'll watch it here in the courtroom and then they'll go back again.
You will ask them for if they want to watch it or?
No, if they ask me, they want,
okay.
yeah.
Yes.
So if y'all want to talk to them about asking again, you can tell them that in closing, that you can tell them, if you want to see it again, you just ask the court. But I'm not doing that because I'm not commenting on what they should or shouldn't look at. I'm just telling you all that y'all can tell them that. Yeah, so obviously I put an alternate on here because I thought we were going to roll over to tomorrow, but I think we're in a really good spot to finish up today. So, so I will address that. Yeah, I'll address that at the end. I've just been bit bad by not having alternates. Those have left a traumatic scar on my soul. So I've just always hedged and always have an extra. So, all right. Well then, any other housekeeping before we bring the jury back out, Ms. Sexton?
No, Your Honor.
Mr. Takmiana?
No, Your Honor.
All right. Whenever the jury is ready, they may come out. And again, if y'all see any errors in here, tell me. All right, you all may be seated. Members of the jury, thank you for your patience on that. I decided to go ahead and do some housekeeping a little bit out of order that I would have had to do later. And so the parties were good enough to let me go ahead and do that now. And so that I think is going to prove to be very efficient for our time. So, so I just wanted to apologize. I told you you'd be out just for a minute. You were out for longer than that. But I appreciate that. And we're going to jump back in. So as you'll remember, Ms. Sexton had called a couple of witnesses. And so we're between witnesses. So Ms. Sexton, you may call your next witness.
Your Honor, the state.
All right. So the state has rested, which means the state has given you all of the evidence they expect to give you in this case. As you've heard me say earlier, the burden of proof is on the state, and the burden never shifts to the defense. The defense has no obligation to testify, nor any obligation to present any evidence or do anything else. However, Mr. Takbianan, you do have the opportunity at this time to testify if you wish, but you don't have to. Do you understand those options?
Yes, Your Honor.
Do you wish to testify or do you wish to remain silent?
I wish to remain silent.
All right, thank you very much. Members of the jury, his silence shall not be held against him, and I will charge you that at the end of this trial, that you will not hold that against him. The defendant has an absolute right to remain silent. The duty is upon the state, and it never leaves the state to prove the guilt beyond a reasonable doubt. Given that the state has rested and now the defense has no evidence to present, that brings us pretty quickly through a series of steps that I thought were going to take us most of the afternoon. As you can see, they're not. What's going to happen next is the evidence is now closed. You have heard the evidence that you're going to hear on this case. What's going to happen at this moment is this is my time to shine. I'm going to read you the law, which is as boring as it is important. And so you will have this copy with you in the jury room during your deliberations. You will also have a copy of the verdict form with a copy of the document that I've been reading to you, which was the accusation filed. So I'm going to read you a good bit of the law here right now, and then we're going to pivot into closing arguments. Now, under Georgia rules, the way courtrooms work, the state has the right to do what's called first and last. They call it, it's a very poorly named, opening, closing, and closing. So I just call it first and last. The state has the right to go first and last. Do you know which of those you're going to wish to do?
Last, Your Honor.
Last. Okay, so they can go first, last, or both. Ms. Sexton is elected to go last. So here's how things are going to go. I'm going to read you the majority of this document, which don't let the size scare you. It's in big font because I need glasses. Then when I'm finished, Ms. Sexton will give you her closing argument. Mr. Takbianan will give you his closing argument. I will give you the last couple of items to tell you what's going on here, and then you will have this case to decide. Now, you are a jury of 6. You just did the math in your head and realized that there are 7 of you. One of you was an alternate in case we rolled over till tomorrow. I'm not allowed to tell you which, but at that moment, one of you will be released from jury service, and I'm sorry for that. If it makes you feel any better, I too was an alternate on a 3-week jury trial many years ago, and I knew it because I knew how to select a jury. So, all right, with that said, here we go. Members of the jury, this is your charge. This is the state of Georgia versus Walter Montanan Takbanian. This is the state court of Spalding County, and this is accusation 25 TK 1651. This accusation was filed on September 30th of 2025. You are considering this case as the state of Georgia versus Walter Montanan Takbanian. The defendant in this case has been charged in an accusation filed by the Solicitor General of Spalding County with count 1, too fast for conditions, and count 2, following too closely. The accusation is on page 2. It is attached behind the verdict form when you get it back into the jury room. And I'm going to read it to you one more time to make certain you understand the charges. This is the accusation. It's the state of Georgia, the county of Spalding. On behalf of the people of the state of Georgia, the undersigned, as prosecuting attorney for the county and state aforesaid, does hereby charge and accuse Walter Montanan Takbanian with the offense of too fast for conditions, for that the said accused in the county and state aforesaid, on or about the 26th day of April 2025, did unlawfully drive a motor vehicle upon a public roadway at a speed greater than is reasonable and prudent under the conditions, and having regard for the actual and potential hazards then existing. That's count 1. Count 2 reads, the undersigned, as prosecuting attorney for the county and state aforesaid, does further charge and accuse Walter Montanan Takbanian with the offense of the following too closely, for that the said accused in the county and state aforesaid, on or about the 26th day of April 2025, did unlawfully, being the driver of a motor vehicle upon a public roadway, did follow another vehicle more closely than is reasonable and prudent, having due regard for the speed of such vehicles and the traffic upon and the condition of the highway, contrary to the laws of the state, the good order, peace, and dignity thereof. Patrick M. Shepard, Solicitor General, Spalding County State Court. This accusation was filed in this court on the date above, and to this accusation, the defendant has entered a plea of not guilty. The accusation and the plea of not guilty form the issues which you have been selected, sworn, and impaneled to try. The defendant is presumed innocent unless and until proven guilty. The defendant enters upon this trial of this case with a presumption of innocence in their favor. This presumption remains with the defendant until it is overcome by the state with evidence that is sufficient to convince you beyond a reasonable doubt that the defendant is guilty of the offense charged. Proof beyond a reasonable doubt. No person shall be convicted of any crime unless and until each element of the crime is proven beyond a reasonable doubt. Burden of proof. The burden of proof rests upon the state to prove every material allegation of the indictment and every essential element of the crimes charged beyond a reasonable doubt. There is no burden of proof upon the defendant whatsoever. The burden never shifts to the defendant to introduce evidence or to prove innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the accused beyond all doubt, nor to a mathematical certainty. A reasonable doubt means just what it says. It is the doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt. It is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of evidence, or a conflict in the evidence. After considering all the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, that is the doubt of the law, and you must acquit the defendant. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict the defendant. If the state fails to prove the defendant's guilt beyond a reasonable doubt, it would be your duty to acquit the defendant. Evidence. Your oath requires that you will decide this case based upon the evidence. Evidence is how any fact that is put into issue is established or disproved. Evidence includes all of the testimony of the witnesses and any exhibits admitted during trial. Evidence does not include the accusation, the plea of not guilty, the opening statements, or the closing arguments of the attorneys, nor any questions that are asked. Direct and circumstantial evidence. Evidence may be either direct or circumstantial or both. In considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact. Circumstantial evidence is proof of a set of facts and circumstances that tend to prove or disprove another fact by inference. There is no legal difference in the weight you may give to either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct or circumstantial or both, excludes all reasonable theories of innocence and proves the guilt of the accused to you beyond a reasonable doubt. Credibility of the witnesses. You, the jury, must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner of testifying, their intelligence, their means and opportunity for knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. To impeach a witness is to show that that witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified, or another way to talk about impeachment is that the credibility of the witness may be attacked by disproving the facts of which the witness has testified. Defendant's choice not to testify. A defendant in a criminal case may take the stand and testify and be examined and cross-examined like any other witness. If the defendant had chosen to testify, you would have been able to evaluate the testimony as you would of any other witness. However, a defendant does not have to present any evidence, nor is a defendant required to testify. If the defendant chooses not to testify, you may not consider that choice in making your decision. The defendant is charged with a crime against the laws of the state. A crime is a violation of the law of the state in which there is a joint operation of act and intent. Intent is an essential element of any crime and must be proven by the state beyond a reasonable doubt. Intent may be shown in many ways, provided that you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or the acts and conduct, and may be, in your discretion, inferred when it is the natural and necessary consequences of the act. Whether or not you draw such an inference is a matter solely within your discretion. Now, criminal intent does not mean the intent to violate the law. It simply means to intend to commit the act that is prohibited by law. No defendant will be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon the consideration of words, conduct, demeanor, motive, or other circumstances connected with the act to which the accused is being prosecuted. Count one, too fast for conditions. No person shall drive a vehicle at a speed greater than is reasonable and prudent under the conditions and having regard for the actual and potential hazards then existing. Consequently, the foregoing, every person shall drive at a reasonable and prudent speed when approaching and crossing an intersection, a railroad grade, approaching a curve, or when traversing a hill. When traveling upon narrow or winding roads, or any special hazards that exist with respect to pedestrians or other traffic, or by reason of weather or highway conditions. Members of the jury, the driver, following too closely, count two. Members of the jury, the driver of a motor vehicle shall not follow another vehicle more closely than is reasonable and prudent, having due regard for the speed of such vehicles and the traffic upon and the conditions of the highway. Venue. Members of the jury, the accusation alleges that each of the alleged offenses charged here in Spalding County. The location of the offense within Spalding County is an essential element of the offense and must be proven beyond a reasonable doubt by direct or circumstantial evidence or both. Members of the jury, the law of our state sets a time limit upon which the state in starting a prosecution of most criminal offenses. The defendant is on trial for a misdemeanor offense, and under Georgia law, the prosecution for this offense must begin within 2 years after the offense has been committed. In other words, the accusation of this case was filed with the clerk of court on the date and the title of these charges. If you find from the evidence that the accusation in this case was not filed with the clerk of this court within 2 years after the offense was committed, it would be your duty to acquit the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you as to this law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all the evidence presented. Then you must apply the law that I give you in this charge to the facts as you find them to be. During your deliberations, you must shut off all electronic devices. You must not communicate with or receive any information from or provide any information to anyone by any means about this case. Do not use electronic devices, including a tablet, cell phone, smartphone, computer, or anything that accesses the internet, nor communicate with anyone any information whatsoever, nor conduct any research until after I've accepted your verdict. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given to you in this charge. You are not to show favor or sympathy to one party or the other. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. Do not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, gender, sexual preference, local or remote residence, economic status, for or against either party. Implicit biases. Do not decide this case based on implicit biases. Everyone, including me, has feelings, assumptions, perceptions, fears, and stereotypes. These are called implicit biases. We may not be even aware of these implicit biases. These hidden thoughts can impact what we see and hear, how we remember what we saw and heard, and how we make important decisions. You are making very important decisions in this case. I strongly encourage you to evaluate the evidence carefully, resist jumping to conclusions based upon personal likes, dislikes, generalizations, gut feelings, prejudices, sympathies, stereotypes, or biases. The law demands that you return a just verdict based solely on the evidence and your individual evaluation of that evidence, your reason, your common sense, and these instructions. Our system of justice is counting on you to render a fair decision based on the evidence, not biases. Deliberations. You are only concerned with the guilt or innocence of the defendant. You are not to concern yourself with punishment. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant did commit the offense charged in a specific count of the accusation, then you would be authorized to find the defendant guilty on that count. And in that event, the form of your verdict would be, we, the jury, find the defendant guilty as to that count. And you will see here on the verdict form where it reads that, and then it says as to count one, and you would circle not guilty or guilty next to each of the two counts. If you do not believe that a defendant is guilty on a specific count, or if you have any reasonable doubt as to the defendant's guilt as to that specific count, It would be your duty to acquit the defendant as to that specific count, in which the form of your verdict would be, we, the jury, find the defendant not guilty as to that specific count. The accusation has the verdict form attached to it, and of course, there's a place for you to indicate your verdict on the bottom of the verdict form by circling as appropriate. As to each individual count, your foreperson will circle the words either not guilty or guilty, and this would be what you have unanimously found. Whatever your verdict is, it must be unanimous. That is agreed by all. The verdict must be signed by one of your members, the foreperson, signed and dated, returned to be published in open court. Please make certain your verdict is ink, not pencil. And then once you get back there, your first duties will be to select one of your foreperson to act, to preside over your deliberations, who will sign the verdict to which all of you have freely and voluntarily agreed. You'll need to make fully independent and separate decisions of not guilty or guilty for each of the counts regarding the defendant in this case. Those are my instructions so far. I've got just about a page and a half left that I will give you at the conclusion of closing arguments, at which point you, the jury, will have this case for deliberations. All right. Ms. Sexton, as you have waived opening and reserved closing, is that correct?
Yes, Your Honor.
All right. Mr. Takbianen, this is your opportunity if you wish to make a closing statement. Would you like to make one at this time?
Yes, Your Honor.
All right. And members of the jury, I'll just remind you that nothing the court says at any point is evidence. Nothing that they say at this point is evidence. Closing arguments are just that. The floor is yours.
The jury, as I reminded you about the first witness, said that she slammed on the brake due to the second witness, Ms. Shaw, who did not stop properly on the shoulder. But at my point of view, as I saw the video, there was level field on the middle that you can further park in order to safely park. But as you saw in the video, when I hit the first car, the red car abruptly moved forward again. That means she knows that she didn't stop properly. And the third witness testified that the road conditions were perfectly normal until there was a traffic danger ahead of the road that was hidden from me. As you saw in the video, I was following a black car that I am not aware of. Ahead of the black car, that there was a car that's perfectly stopped or dead stop on the middle of the road, which is improper stop. And as you saw in the video, I was far behind the black car. I was following a 3-second rule. The 3-second rules is you count from 1, 2, 3 that you are away from the car you're following to make sure you safely stop. But because of the unexpected event that there was a hidden danger in front of me, that even this 3-second rule, I still hit the car from behind. But by doing that, I also saved from getting fatalities, because I see on the road every day, there's a cross there, somebody died in an accident, and that is a sad sight to see. And as you know, the sheriff also testified that he was investigating after the accident, but he is not aware of the actual accident when it happens. So you have all the evidence, and just by the two questions, the two accusations that I'm accused with, which is based on the evidence and the testimony of the witnesses, do you find beyond reasonable doubt that I was too fast for road conditions when the hidden dangers are present in front of me and the accident happened? And was I following too closely when it happens. These are the two charges. And based on the eyewitness and the video you just saw, you may decide either I'm guilty or not guilty, but I plead to you to make the decision, the right decision. Thank you, Your Honor.
All right, thank you, Ms. Tatiana. All right, Ms. Sexton, the floor is yours.
Okay. Good afternoon. I've tried to make this as simple as I can by putting up not one, not two, not three, but 4 witnesses regarding this. But I've tried to do it very quickly and very succinctly. And I've also admitted into evidence the dash cam from the defendant's vehicle. Now, I'm going to go over, because that accident footage is short. I'm going to point out to you what I would like for you to look out for, because I'm going to replay it at the end of my closing for just a moment. It will not take up that much time. But it is hard to see what that video tells you, the story it says, because it happened so quickly. It's a short video. What the video will show you, what the story will show you, and I invite you, if you cannot take it all in by seeing this video when I re-show it to you, you have the opportunity to take it back into the evidence room and watch it again. This is very important, because how often do we get to see exactly what happened? 9 times out of 10, we're talking about an accident that the investigator comes upon the scene afterward. Well, this is amazing. Think about this. You have 3 people talking to the officer. You have the officer, and their conclusion, based on their experience and their training, is that A, this is the way the accident happened. The defendant was driving too fast for conditions, and he was following too closely. We didn't have the defendant's dash cam. We didn't have it. We had a body cam, and we had a dash cam from the police vehicle, which I decided not to show anybody because it takes up a really long time, because he's there asking if everybody's okay. There's EMTs in it. There's all kinds of stuff happening. But it's after the fact. What a jewel that we have something that's basically showing you exactly what happened. And this is what happened. This is the story. We have Mrs. Shaw. She was the young girl in the black sweater that testified that she saw a funeral procession. She was heading north. The funeral procession was heading south. Unless you look really, really, really closely at the video, you're not going to see that, because it's all happening so fast. But when you see the video again, look to the left. You're going to see a police escort with flashing lights. You're going to see a procession with all headlights. You're going to see a hearse. This is what she saw. And she was raised by a mama and a daddy that said, when you see a funeral procession coming on the other way, out of respect, you pull over to the side of the road. She was in the left-hand lane when she saw this. She could not pull over to the right. She chose to pull over to the left. When she chose to pull over to the left, she could not go all the way down. When you see the beginning of the video, you're going to see that the swale is relatively flat. But as it goes further, the swale in the road goes deeper. She made a decision not to drive into the swale of the road when she had a 4-year-old in a car seat in the back. She stopped. She went to the left. She did not pull off entirely off the road. She did pull off over the yellow line. And hey, do you know how we know this? Because the police officer investigated it afterwards. As he showed you, I look, where's the point of impact? Where's the glass? Where's all of this stuff? I am trained to come upon this accident and be able to put the pieces together to that puzzle. So what do we have? What does the story say? What does the video say in less than 2 minutes? In less than 2 minutes, it says, there's a funeral procession with a vehicle with flashing lights that's heading south. Mrs. Shaw, driving a red car, pulls to the left. Not all the way into the median, but she pulls to the left. She can't pull to the right. She pulls to the left. A truck, look at the video carefully because you're not going to see it because it happens really fast. There's a truck behind her. It goes around her. And how do we see this on the video? What is the video showing us? The video are the eyes and the ears of the driver. If the video was recording something, it was recording it because we could see it through the windshield. If the defendant didn't see it, it was because he wasn't looking, because the video is showing what he saw, exactly what he saw. So what the defendant saw was a funeral procession. What the defendant saw was a red car that had they didn't see the red car. To be fair, the red car wasn't seen, but you could see a truck which all of a sudden went around. Then what you could see was a white car. Then what you could see, this is very important, pay attention to this on the video. There is a black car. They are just tooling along. It's in the middle of the day. Their brake lights go on. I don't know about you, but when I'm driving and I see one car go around and another car with brake lights in front of me, I slow down. There was no slowing down. When that when that black car with those taillights, with those brake lights that came on, there was no slowing down by the defendant. What else are we going to see? You're going to see video that shows that the white car was far enough behind the red car. Think about it. If the white car had screeched to a halt and barely had stopped and barely made it, and you can't fit a piece of paper between those two cars, if that car got hit by his vehicle, which was traveling at the speed limit, that car would have gone smack into that red car. But that's not what happened. That car got hit and it went around. Why did it go around? There was enough time. That white car was so far behind that red car that when it got hit, it went around. It didn't even scratch that car. How many times do we see this happen? How many times do we see a video of exactly what the defendant saw? The white car goes around the red car. Now, what do we know? The white car got hit in the rear. What is the duty of a driver? If you're driving forward, you have to be going a safe speed and you have to maintain a safe distance, because if you hit somebody in the rear, you're driving too fast and you're driving too close. Now, did we have an accident that happened in a split second in front of him that it was a definition of an accident? No. There were lots of cars that avoided this accident, and pay attention to the black car with the brakes. Seldom is there such clear evidence of an accident. And remember, this isn't my evidence. This is the evidence the defendant brought into court that I saw 5 minutes before this court started. Now, what does this mean? We are not saying, we the state are not saying that the defendant is a bad person. I think we have a difference of opinion here. The defendant has shown up in a suit. He's been respectful to the court. He's been respectful to the jury. I'm not calling him a bad person. All I'm saying is, on this day, at this moment, at this time, for this 2 minutes, he violated the laws in the state of Georgia by going too fast for conditions and by following too closely. Now, he talks about the 3-second rule and following. Again, I'm just going to ask you to look at that video and watch that black car's brake lights come on. So what does the evidence show? What does the testimony show? What does the video show? It shows that Mrs. Shaw, red car, driving north straight down Georgia 3. She slows down and she stops for a funeral procession heading the opposite direction. She did not turn all the way off the road, but she went to the left. She was in the grass. Mrs. Burrell, the white car, safely stopped and was not involved in an accident from her own actions. The defendant, who was traveling behind her, is coincidentally too close and driving too fast to be able to stop. The damage is to the front end of the defendant's car. The damage is to the back end of Mrs. Burrell's car. Following too close. That's what happens. So let's talk about the credibility of the witnesses. We have 2 witnesses who are not even involved in the accident. They have no property damage. They have no dog in the fight. The reason they were here today is because the state subpoenaed them to say, please help us tell your story. They're completely unbiased. They didn't have property damage. They weren't hurt. You heard from Mrs. Shaw, who testified she stopped for the funeral procession. You saw evidence from Yolanda Mayo. She stopped 8 cars after the accident. 8 cars went by safely. She was in the van that pulled over to the side. She's just a good Samaritan. She saw it happen. She wanted to make sure everybody was okay. She was on her way to work. She just got back in the car. You heard the officer testify. It's very objective. You come in, you look at where the property damage is, you look at where the grass, you look at where the glass is broken, you look at the butt of one car, the front of another car, you talk to all the witnesses, you make a decision. He writes up this report without ever seeing this camera footage. And I'll be darned, the camera footage is exactly like the police report. Exactly. That doesn't happen. Like, think about it. Think about the chance that you're dealing with 3 different people's stories. So let's talk. So first of all, we have the evidence, which is the testimony of the people. We have the damage to the vehicle. You saw the white car get hit. The last bit of evidence is the video. I'm going to show it to you one more time at the very end, and then if you need to see it again, you can see it in the jury room. The only reason I'm showing it to you again is it's the story. Everything about it is the story, but it's so short, you're gonna have to look at it like this. You're gonna have to see the funeral procession. You're gonna have to see all the cars that are avoiding it. Look for the brake lights on that black car. Okay, so what is the law? We're charging you with understanding the law to decide whether or not this person violated the law. So let me help you with the law. The first thing is following too closely. Okay? This is what the law says. The driver of a motor vehicle shall not follow another motor vehicle more closely than is reasonable and prudent, having due regard for the speed of such vehicles and the traffic condition and the condition of the highway. stopped for a funeral procession. A bunch of cars stopped. Okay, now let's look at following too closely. Remember this about following too closely. Nobody accused the defendant of breaking the speed limit. He did not get a ticket for going over the speed limit. He got a ticket for violating the law, which basically says that he was driving too fast for conditions. No person shall drive a vehicle at a speed greater than is reasonable and prudent under the conditions, and having regard for the actual and potential hazards then existing. Hazards. There's 2 cars stopped. That's a hazard. Consistently with the foregoing, every person shall drive at a reasonable and prudent speed when considering the conditions of the weather or the highway. Okay, so I am not going to try to keep you any longer, but I am going to show you the video one last time. I'm going to ask you to remember that when the defendant says, I did not see this happened suddenly, I did not see it, I came upon it, his dash cam is recording what he saw. Now, if he wasn't paying attention or he wasn't deciding, making decisions about what he was seeing, it does not change the fact that that is what he saw, and that is what happened in Spalding County on 4/26/25. Let me show it to you one more time, and I believe that's at the end of the day, from the testimony, from the video, I believe from the testimony and the video, the state has proven that the defendant has violated 2 laws, following too closely, too fast for conditions. And let us all remember, this is not a life and death situation. These are traffic tickets. These are traffic tickets. However, you heard Ms. Burrell stand up there and say, this is her mother's car. It had to be repaired. It was out of commission for 3 weeks. There are repercussions for not doing the right thing. Thank you for your time. I'm going to show you the video now. Okay, Your Honor.
Ready? All right, there we go.
Now remember, this is going to go very fast, people, so try to remember what I said. Funeral procession, flashing lights. Car moving over to avoid. Black car with hit.
Okay. All right, anything else, Ms. Sexton?
No, Your Honor.
All right, members of the jury, last couple of bit of housekeeping, and then this case will be yours. As you, in just a moment, you will retreat to the jury room to begin your deliberations. You must start your deliberations with an open mind. You must consult with one another and consider each other's views, but you must decide this case for yourself. But you should only do so after a discussion and consideration of this case with your fellow jurors. Do not hesitate to change an opinion if convinced it is wrong. However, you should never surrender an honest opinion simply to be congenial or to reach a verdict solely because of the opinions of the other jurors. Members of the juries, by no ruling or comment has the court made during the progress of this trial, has the court intended to express any opinion upon the facts of this case, the credibility of any witnesses, upon the evidence, or the guilt or the innocence of the defendant. The court's sole interest is that this trial be conducted fairly and in accordance with Georgia law. Once you have reached your verdict on each count, you will notify the bailiff. Your foreperson will bring the verdict form out to the box. I will identify your foreperson on the record, and I will ask your foreperson if you have reached unanimous verdicts on each of the charges. If the answer is yes, your foreperson will give the signed unanimous verdict to the bailiff, who will pass it up to me. I will look at it, confirm that it is in proper form, and then I will read the verdict out to the courtroom. In just a moment, y'all are going to retire. I'm sure you all did the math and figured it out. Mr. Reagan, you all are alternate, which means that if you'll stick around just a minute after they're done, I'll give you a different set of instructions. But for the rest of you all, please retire to the jury room, but do not begin your deliberations until you received these directions, this form. And I guess you won't actually have a copy of the exhibit with you because but if you need to watch it again, as you heard them say in closing, if you do want to watch the video again, you just ask. I will bring you back out into the courtroom. We will all sit silently. They will play it. No one will say anything or put anything on the record. And then I'll have you step back out. So in your foreperson, if that's what you want to do, just have your foreperson send a note out that that's what you all would like to do. All right, that's it. Thank you all. You may step back in the jury room. She's got to stay there. I'm going to have to do a new one.
I told her to sign it. She's still guilty of this.
Is she gone?
No, I told her that.
Yeah, she needs to come back in and sit down.
Well,
Okay.
that was on paper.
So I'll just bring Miss Juan back in and say, you didn't do what you're supposed to do. Come sit back down. Because that's the second time she's not done what she's supposed to do. No good deed goes unpunished. All right, back to Mr. Takviana. All right. Mr. Reagan, you have served well. I always bring an alternate if there's a chance of an overnight. So, do you have items back in the jury room there? I assume no. Okay. Well, you know that old joke of like I went and did this and did that, and all I got was this T-shirt. Well, all you get is the button. So the button is yours to keep. It's a little memento of our day together. I am grateful for your service. I know we all are. If you want to stay, you can. If you want to go, you're welcome to go. Whatever you want to do next is completely up to you as long as you don't go in the jury room. So what would you like to do? Or do you have any questions? Go home. Okay. Then you are good to go. If you'll give Miss Margaret your notes, she'll make certain they get destroyed properly. Thank you again for your service. Do you need anything from the clerk's office? Okay, then you may come across. And y'all bring Miss Wong back up, please.
Because I think we just need to arrange this.
Well, I was trying to do that quietly and get her out the door because she was in a hurry to go and she didn't follow directions. So we're about to do that again. So. All right, we're ready for her.
If you could make sure that on that thumb drive, that's the only thing that's on there is that one video, because I'll need to keep that.
Okay,
good
okay.
record.
I will.
So if you have anything else on it, then you can take it off.
This is hers.
Oh, that's her copy? Oh, okay.
Do you?
But
you can
I
have
need
it?
to give you yours because you
Okay.
gave me.
Okay.
Okay, well then,
All right, everybody, let's come back on record. Does anybody need a break or anything before we officially get started? Okay. All right. Mr. Takbianan, there's a verdict. So what's going to happen next is the jury is about to come out, and they've seen the verdicts before, but you have not. And the way it goes is the jury will step out, the foreperson will have the verdict form in their hands, and I will say, please identify yourself, and they'll say, my name is John Doe. I'll say, are you the foreperson? They'll say yes, and I'll say, have you all reached a verdict? They'll say yes, and I'll say, don't tell me what it is, but have you all reached a unanimous verdict on all charges? As in, like, have you talked about each of the charges and reached a decision that all 6 of you agree? The answer is yes. I'll say, have you written that verdict on the form by circling the appropriate and signing it? And they'll say yes, and I'll say, well, please hand it to Miss Margaret. Margaret will take it, she'll hand it to me. I will look at it to make certain it's in proper form, because sometimes they're not. If I determine it's in proper form, I'll then read it out loud to you all. At which point, if it's, and then I'll pass it down to be stamped in, get you all a copy. And then I'll ask if we need anything else from the jury. And so if you have anything else from the jury, that's the time to ask. Otherwise, I'm going to release the jury. We'll stick around. And then if it's not guilty, then obviously you'll be free to go after a little bit of housekeeping. If it is guilty, I'll sentence you after a little bit of housekeeping. And so do you have any questions for me about anything
Your
before
Honor.
we go forward?
No, Your Honor.
All right. Ms. Sexton, you need anything else before we get going? All right. All right, Miss Margaret, if the jury is ready to come out, they may come on out. Thank you for talking me back off the ledge with that long. Yeah. All right, you all are back out here. Y'all may be seated. All right, it looks like you are the foreperson. Is that correct? Yes, sir. All right, so if you'll stand up, we'll do a couple of very basic questions. Hopefully none of these should scare you too bad. You ready? Yes. What's your full name?
Lisa Hardy.
All right, Miss Hardy, you are the foreperson, correct?
Yes,
Has the jury reached a verdict on each of the charges?
yes, we have.
Is it unanimous? Is it agreed upon by all 6 of you?
Yes, it was.
Have you recorded that verdict as you all have agreed on the verdict form I provided?
Yes, sir.
Did you use ink, not pencil? Okay, if you'll pass it to Miss Margaret. Thank you so much. Oh, and you even brought the charges back out. Thank you so much. Okay. The verdict is in proper form. It reads, we, the jury, find the defendant as to count 1 guilty and as to count 2 guilty. You all come up and take a look at it. See if there's any objections as to form. I'm sorry.
No objection, Your Honor.
Okay. All right, I know it's not the verdict you wanted, but do you see anything that's wrong with it as far as the form goes? Okay, all right, we're good to go then. All right, anything else from the state before I release the jury?
No, Your Honor.
Anything else, Mr. Takmani, before I release the jury?
No, Your Honor.
All right. All right, members of the jury, this concludes your service. So I just wanted to say thank you, thank you, thank you. Again, before COVID, I used to say things like, I can't imagine a world where we can't try jury trials. And now I can imagine it well, and it's very, very difficult to do anything because we have a system where we bring our issues to you all, and we ask you all to help us sort them. And you all very kindly give up your days and your lives to come here and to do this. So thank you, thank you, thank you. Thank you for all of us who are here. Thank you. Please tell the people around you thank you, because I'm certain that there are friends and family and workers and coworkers and bosses and people that answer to you who are having to do more because you're not there doing what you would normally do today. So please tell them we said thank you across the board. Do any of you all need anything from for your employers, any sort of any sort of notice or anything else? Okay, no, or is good. All right, so I've been telling you all along, you can't talk about the case, you can't, speak about it, you can't do any homework. That's all gone. You can talk all you want or not at all. It's totally your decision moving forward. So Ms. Sexton and Mr. Takmian may want to speak with you out in the hallway. If you want to speak with them, that's normal. That's part of what we do. Just hang out there for a minute and they'll come out. If you don't want to talk to them, then just get on the elevator or go down the stairs and you're free to go. This is not much, but those badges that have, those are yours to keep. So just a tiny little memento. But there's one rule, which is you can't wear it back to the courthouse. So, because I'm about to release you, and that means that would be really, really awkward. So please don't release it back. Make certain that you put your notepads face down. Whatever bag you've used or whatnot, I think y'all put it in bags, didn't you? That bag's yours to keep, whatever notes are in there or whatnot, but leave the notes. I'm sorry, what else is in there? Not the notes. Leave the notes face down. They'll destroy them. They'll never see the light of day. Do any of you have any questions for me that I can answer before we part ways? All right, so y'all are good to go. Thank you.
Turn that paper in that you're to fill out with the questionnaire that was sent with the.
Oh, if I'm about to release you, so if you're talking about the questionnaire that originally came with your summons, you don't have to worry about that at this point. So that was for a whole different setup. It's okay. So, all right, good question. Anything else? All right, well, if y'all will grab your items and then just head on out the way you normally do. Thank you all very much. And again, if you want to talk to them, you can stand out there just for a minute. They'll be out shortly. Here, Carly.
Do you want the original tickets? What do we do with the original tickets? Is this where we?
I don't think we have any need for them. I mean, Carly's already got the scans.
Okay, that's fine, I just,
As far as I'm concerned, they're yours.
okay.
So. Mhm. On record. All right. Mr. Takbianan, the jury has found you guilty on both of your charges. I just want to say again, I thought you did a good job representing yourself.
I thought so too, sir.
And the fact that you dressed up and wore coat and tie to court today was not lost on me either. Does the state have any preference on sentencing before I issue my decision?
These are payable tickets, Your Honor. I see no reason for anything other than a fine
Okay.
on the tickets, and I think the tickets each have a 306, but that's at your discretion.
I think that's reasonable. I think this was a reasonable case to try. So I think this was a reasonable case to try. I want you to hear me say that. Sometimes, I mean, if we get to the end of a trial and I think we have just wasted everybody's time, I will say it. I do not think that in this case. I think it was a reasonable case to try. The jury has issued their verdict. And so I'm actually just going to let you, do you have the ability to pay the fines today?
Yes, Your Honor, but after the accident, I lost that car. I lost my dad in a couple of months, and then I lost my job too.
Oh.
So it's really hard on me.
I'm so sorry. Well,
And I lost the case.
yeah, you did. So
it's a
so
really
most
hard
important of all, I'm sorry you lost your dad. That, you know, that is tough. Well, frankly, normally the way this works is I'm kind of, I don't know, this is not a good analogy, but it's the best bad analogy I have. I'm kind of the fixed point off in the distance. So I'm the manufacturer's suggested retail price. I'm what the court should punish you as if the jury finds you guilty. The negotiations, which was what was offered to you before, is usually a reduction because it's what you all can agree to.
Yes, Your Honor.
I'm simply saying in this case, and I don't normally do this. In fact, I can't think of another trial that I've ever done this, but I think this is a reasonable one. I can't think of another example where I've done this. I'm going to just let you out of here with what they offered you. So I'm going to let you have what they offered. They offered, what, 306 per charge? Was that what it was? So I'm going to let you out of here at 306 per charge.
Thank you, Your Honor.
So I'm honoring what they did because I thought you were respectful to the court. I thought you did a good job. I thought this was a reasonable case worth trying. And frankly, I wish every defendant came in here and tried their case in the way you did. Most
you.
folks were lucky that they're even fully clothed. So you did a great job. Okay.
Thank you, Your Honor.
All right. And you said you do have the ability to pay that today?
Yes, Your Honor.
Okay,
My
so-
credit card is accepted.
Yes, credit card is, otherwise I got to put you on probation and I'm trying not to do that.
Yes, Your Honor.
What card?
I
don't
believe
care,
it's
but they
either
do.
MasterCard or Visa.
Okay.
It should be
They're
accepted.
saying yes to that. So,
Okay.
again, I'm just trying to make certain I can get you out of here today without having to come back.
Yes, Your Honor.
Okay, well then I'm going to let the bailiffs and Ms. Carly walk you down. Again, thank you for the respect you showed for this court, the respect that, I mean, I saw you interacting with Ms. Sexton on multiple occasions. You clearly interacted with her with respect. And we tried to extend that to you. So I hope your interaction with this court left you feeling the same way. All right. Well, that's it. Does anybody else need anything else? Because I'm about to close the whole calendar out. All right. Then the court is adjourned. The calendar is adjourned. Don't forget, everybody, Wednesday morning, state cases. We'll do it here in this courtroom. And our second courtroom is this close to being ready. So we'll be there soon enough. Anything else, Carmen?
Thank you, sir.
I want you to walk away knowing you did a good job.
You're doing that one, it's at 9. There's two calendars. There's one at 9 and one at 1.
I'll pay.
That's a different
You will escort me. Oh, thank you, man.
Judge Howell runs those.
Thank you.
You did a great job. You did a great job. And I meant what I said when I said